Hi again, Attorney Steve Vondren. We're back. In this video, we are talking about the very important topic of Cumis Counsel. Cumis Counsel, what's that? Let's go real quick to the Attorney Steve litigation whiteboard. Okay, so let's back it up here and let's talk a little bit about Cumis Counsel. I know there's a lot of stuff on the board here. We're going to check off a few items. This is some of Attorney Steve mind mapping. So we're going to go through some of our issues with Cumis Counsel. Okay, you can find out more information first of all at cumiscounsel.info. That's COUNESCL.info. Cumiscounsel.info. Now, Cumis Counsel is basically when you have the situation where, let's say you're sued as a real estate broker. You're sued for negligence and breach of fiduciary duty and fraud. Well, normally you have an errors and omissions policy that's going to cover and protect you in the event that you get sued, but that policy doesn't cover everything and it only goes to a certain limit. Okay, so if you're sued for a $100 million loss on a commercial building, chances are that's not going to be covered by your insurance policy. So what happens is you get sued, you get served with a lawsuit, you're going like, oh my God, I've been sued for all these things, fraud, misrepresentation, breach of fiduciary duty, negligence. You're being sued for everything under the sun, financial elder abuse, all these different kinds of causes. First thing you do normally is you contact your insurance carrier and say, I've been sued, I need representation, and you do what's called tender your defense to the carrier. Tender your defense to the carrier saying, pick me up on this. This is why I pay all the premiums and the policies and everything. So your insurance carrier will then review the case and decide whether it wants to pick up your defense. And in most cases where you have simple errors and omissions, that's going to be covered. But lots of times in these complaints, you have all sorts of different allegations, different facts roaming around, some true, some untrue. And you send it to the carrier and the carrier says, well, we're going to defend you, but we reserve our rights, what we call a Reservation of Rights letter. And that letter basically says, I want to be able to come back at you if I need to. If it turns out that you were committed acts of fraud, we're not covering you for that. You're on your own. So you have reservation of rights that will allow our carrier, if the facts turn out to be fraudulent or some other sort of misconduct that's not covered by the terms of the insurance policy, they want to be able to come back to you as the broker or the real estate agent. They want to come back to you and get their money. So you have to understand, when you get a reservation of rights letter, there is this inherent potential conflict where the insurance carrier is basically signaling to you that they have a divergent interest. So let's go to the whiteboard and talk about some of these issues here. So you have here where basically, and the question becomes, well, what do you do? Do you retain your separate independent counsel, known as Cumis Counsel? And Cumis Counsel is where you get the insurer to pay the defense, where the insurer has to come and pay. So here it is, here's you as the defendant. You tendered your case to your carrier. Your carrier's over here, they're their liability insurance company. They've issued you a general policy of insurance, and they're going to review it and decide. Lots of times we have a third-party claims administrator that we put there, some third party that's going to handle the claim. And they'll decide, yes, we'll cover this. No, we won't cover that. And so this is where your insurer versus your policyholder, this is where a potential conflict can arise, and which of these are going to be covered and which aren't. And then how are you going to be properly defended if your insurer is not covering you, is basically reserving its right to not cover you on some of these other items? Perhaps they would rather have fraud proven against you. Do you see what I'm saying? Perhaps they would rather have it shown that you were committed acts of fraud. Then they wouldn't have to pay, and they could come back and get their costs that they've expended against you. So there's a potential conflict, as you can see, when a carrier doesn't, when it reserves its rights and doesn't pick you up on all the claims. So then what you get is a reservation of rights letter, basically telling you all this is going on, asking you for more facts, appointing your counsel. As we point out here, you're going to get your counsel. You're going to get your counsel appointed for you here. The insurer has the right to pick the counsel, and that becomes basically your what we call your defense panel, your defense firm. The insurer has the right to control the defense. Now, lots of people may say, well, that's weird. It's my future. It's my name. It's my reputation. It could lead to a potential issue with the Department or Bureau of Real Estate. Don't I get to tell the defense company that's representing me that I have an attorney-client relationship with? Don't I get to tell them how the defense is going to proceed? The answer is no. The insurer has the right to control the defense. Now, one thing you want to bear in mind whenever you hire an attorney is any actual or potential conflicts of interest need to be disclosed by your insurance defense form. That's our rules of professional conduct. 3-310 is our rules of professional conduct. So check out that section. And one thing that I would demand if I was the client is I would want to make sure that they're disclosing all the potential conflicts that may exist to me in writing so that I can see if I want this firm to represent me. There may be a reason I don't want this firm to represent me, even though the insurer has the right to appoint their counsel. Those objections would need to be made on the record, okay? So you want to get that out. So you have this firm, you have your insurer, you have the defendant, that's you, that's the broker named in the lawsuit, and over here you have your plaintiff. The plaintiff is going to raise your allegations, as we mentioned, various causes of action, and an allegation is not fact. They're allegations that are things that are alleged against you that need to be proven. So you have your allegations. This is what the carrier is going to look at. They're going to look at the allegations in the complaint, compare that versus your insurance policy, and determine the scope of coverage in your case and whether or not they're going to issue that reservation of rights letter. Okay, so as you can see, it creates what we call a tripartite relationship. Tripartite relationship, you have three parties. You have the defendant, the insurance company, and your insurance carrier. So you have sort of these three parties. The law firm has a duty to the carrier because they're appointed by the carrier and they're working to minimize the risk and exposure for the carrier, while also owing a duty to the client, the broker, you, under basically attorney-client rules and rules of professional conduct. So it creates this what we call tripartite relationship. Normally there's going to be a common shared interest to get this resolved, but sometimes there's not. And that's where you need to understand, do I need Cumis Counsel? Now, let's talk about what is Cumis Counsel. Cumis Counsel arises in the case San Diego Federal Credit Union versus Cumis Insurance Society. So that's why we call it Cumis Counsel now. Okay, 162 Cal App 3rd 358 if you're looking for that. Right to counsel exists even where it's just a potential conflict of interest, such as a reservation of rights letter. So that's what triggered this whole thing off, got everybody talking about the right to Cumis Counsel whenever an insurance company was reserving its rights. Now, of course, insurance companies didn't love that because then that means they have to go and pay. Defense attorneys to come in and act as Cumis Counsel, creating basically four parties. As you can see, now there's four parties at work, and sometimes the fifth with your claims administrator. So you have this big glop of stuff going on in your litigation cases, and you basically, the Cumis Counsel is going to seek to be compensated from the insurance company, alleging that there's a conflict that needs to be addressed. So if you want to hear more, you're going to have to watch part 2 of this video. We'll be right back.